Hello, YouTube. I'm Vince White. I'm an employment attorney on this channel. We answer publicly posted questions from YouTube users, getting folks the answer they need from an employment attorney. We have a question here, excuse me, from YouTube user Sean Barfield 3162, who asked us, I am currently suing my former employer for racial discrimination and disparate treatment, as well as retaliation. This is the second time I'm suing them. The first time was with the Equal Employment Opportunity Commission, and I was reinstated after that case. I hope you also got paid in addition to reinstatement. Now, after over 20 years of service, I was wrongfully terminated. My attorney has filed my complaint with our state agency here in Pennsylvania back in April of 2023. Pardon me. My former employer has not responded to my complaint. Why would they not respond to the allegations? Okay, so bunch of reasons that might be happening. First and foremost, never count out incompetence in the field of employment law. Especially, and don't take this the wrong way, in small markets like Pennsylvania. And I say this as, listen, I'm from upstate New York. I could walk to Pennsylvania from where I lived, and I often did. I had friends who I went to school with who lived in Pennsylvania, no less. So I'm not, by any stretch, mocking Pennsylvania. But there are some fairly small markets in Pennsylvania. And what you'll find in small markets is that the quality of employment attorney ranges from non-existent to the defense attorneys are terrible and the plaintiff side attorneys don't exist. So it's entirely possible that your employer just doesn't have good in-house counsel, or that the in-house counsel is disorganized, or that they're rushing around trying to find somebody to defend the case for you, against you. Excuse me. And, listen, it could just be that, right? They could be incapable of finding the correct people to defend this case against you, and so they haven't responded. It could be that they're just asking for extensions of time. That's entirely possible. They're rushing around. It could be the facts of the case are hard for them to get together. They're trying to ascertain how badly they messed up, right? Because here it sounds like it's pretty bad, right? You got a retaliation claim in play in addition to everything else, it sounds like. And you've already, it sounds like, succeeded once before. So I would imagine they might be on the run, right? So listen, all that's possible. Inability to find counsel, inability to get their arms around what really happened here, disorganized in-house counsel, all possible, all the most likely, right? But I will float one bit of a outlier idea, bit of a sneaky idea. I was defending a case such as yours. It sounds like a pretty good case, right? Disparate treatment, racial discrimination. You succeeded the first time. Now, all the same claims might be in play, but there's a retaliation claim as well. That's not great for my client if I'm this hypothetical defense attorney. But I noticed that your case is in the Pennsylvania State Agency. And I might go ahead and look at the average verdict in the Pennsylvania State Agency that deals with discrimination claims. And I might say to myself, well, that's pretty low compared to the average jury verdict in this field. So if I don't respond, if my client defaults and they take a big loss, a big L in the Pennsylvania State Agency, they might just schedule an inquest. Just a quick hearing to have the administrative law judge or whoever decides cases in the Pennsylvania State Agency decide the damages on this default. And that would mean the case is over. The case is over, and it's decided by an administrative law judge who's probably way more jaded because they've seen hundreds, if not thousands of these cases, than a potential jury pool might be. So I, as this clever, diabolical defense attorney, have, for almost no billing, done my client the incredible service of keeping a really horrific claim from spiraling out of control, jumping to federal or state litigation, getting in front of a jury, and getting a big effing verdict, right? So hypothetically, if you were the sneakiest, most clever defense counsel, and you saw that maybe plaintiff's counsel was comfortable letting things go to default, or just not particularly watching, right? You might just let it go to default. And you might find that that default result that your client ends up paying out might be lower than the settlement amount your client would have paid out if plaintiff's counsel was threatening to pull the case out of the agencies and go on to federal or state court litigation. In fact, you might even find, hypothetically, could be the case that you would find that the average verdict in the Pennsylvania State Agency, which you should check with local counsel or the agency's own statistics to ascertain, but you might find that it's lower than what your average defense attorney would just charge in terms of their hourly rate to defend a discrimination and retaliation case in federal or state court, let alone what defense counsel would charge to defend, plus what the client might have to pay in settlement. So am I saying that's what they're doing? No. Simplicity, we'll apply Occam's razor. The simplest answer is the best. Incompetence. Disorganization. The mail failed to deliver. So there's many things that could have happened here, right? I'm just saying, if I was to go to the defense side, and my goal was to put up a good, it was not a win for the client's going to pay, right? But to put up a good result on a really bad situation, right? To minimize the payout on what sounds like a pretty solid claim with a good valuation. 20-year success story from a company, lots of seniority, probably has some raises under her or his belt. Looks like his belt potentially. Might earn more than the average employee in the company. Big retaliation, potential punitive damages verdict, right? You look at that, and you say, wow, that's one hell of a pool of damages. I don't care for that one bit. And we're probably going to lose if we don't settle. But if I just let it go to default in the agency, might be cheaper than I even have to pay in settlement, even if the plaintiff's attorney was a little bit lazy and was really hedging for risk, didn't want to do the trial. It might still be cheaper. I don't know that's what's happening. But that's how my mind works. Right? All the rules. It's not cheating if it's within the rules, right? And that defense counsel, no harm, no foul. You can get as mad as you want. They're like, listen, you could have pulled out. I didn't make you file with the state agency. I just let it default. That's within my... I can make a choice to let it default. If that's the best thing for my client, I can choose to do that. And she or he would be absolutely correct. And you would be absolutely screwed. I mean, you'd be getting a check, potentially, right, in this hypothetical. It just wouldn't be a very good check compared to what maybe you could have had. So, have a conversation with your attorney. Maybe. See if the Pennsylvania State Agency is where you want to be. See if you want to escalate, potentially. I think you've still got options, like federal and state court litigation. But talk that over with your attorney. Local counsel can give you a much better answer here. And I'm not allowed to speak the laws of the state of Pennsylvania. I'm just saying this is certainly a topic to discuss with local counsel, and one that could merit a conversation. Anyways, if the dark twists and turns of my mind haven't made you hate me yet, like, subscribe, comment down below, and share the channel so it can grow. Take care, everybody.